Good afternoon, everybody. My name is Vic Amar, and I'm the dean here at the College of Law. And it is my pleasure to welcome you to the Paul M. Van Arsdell Jr. Memorial Lecture on Litigation and the Legal Profession. An Illini three times over, Paul Van Arsdale Jr. was a partner at Latham and Watkins in Chicago. He was an outstanding litigator, where he focused on consumer law, and was regarded by his colleagues as a tireless advocate for his clients and a generous mentor to his colleagues. He became the youngest head of Latham and Watkins' Finance Committee, a demonstration of his firm's deep respect for him and his work. The law firm of Latham and Watkins, the Van Arsdale family, his many friends, colleagues, and clients endowed this memorial lecture series to promote thoughtful discussion on litigation, dispute resolution systems, and the highest ethical ideals of the legal profession. Today, we are delighted to welcome Adam Liptak to the College of Law to deliver this year's Van Arsdell Memorial Lecture. Adam's academic and professional accomplishments and accolades are easy to see and quite impressive. A graduate of Yale College, where he was an editor for the Daily News and Yale Law School, Adam practiced at a large New York firm and in the legal department for the New York Times before joining the news staff at the Times in 2002. Since 2008, Adam has reported on the Supreme Court for the Times. And if you don't already kind of intuit this, being the main person covering the Supreme Court for America's newspaper of record is a big deal. It's a major responsibility. Linda Greenhouse had that job before Adam, and Adam has proven himself a more than worthy successor. In addition to describing and analyzing what the Supreme Court is doing, he writes an in-depth column with a somewhat broader scope on developments in American law called Sidebar, which appears every other Tuesday, and which I highly recommend to law students trying to figure out how to apply what they're learning in their classrooms. Adam was a finalist for the Pulitzer Prize in Explanatory Reporting in 2009 for American Exception, which was a series of articles examining the ways in which the American system differs from that of other developed nations. And he received the 2010 Scripps Howard Award for Washington Reporting for his five-part series on the Roberts Court. And now, 5 years later, Adam will offer some additional thoughts on the Roberts Court at 10. This is an especially important time to be looking at the Roberts Court, I think. Not only is a decade a nice occasion for reflection, but the election of 2016 may determine who will appoint a handful of new justices to the court who could very well alter its current balance. I should note that in addition to Adam's presentation today, a number of faculty here at the college will be taking stock of the Roberts Court in a complementary presentation, albeit perhaps from a law professor's rather than a reporter's vantage point on Thursday as part of the Constitution Day events organized by Professor Jason Mazzoni. And I saw Jason here at some point. There he is, way in the back, backbenching it. If you find the topics that Adam addresses today interesting, I really encourage you to come to that panel as well. On a personal note, let me mention that Adam and I were classmates in law school, along with Professor Richard Ross, who cannot be with us today because of a family emergency that took him out of town. Adam and I didn't spend a lot of time with each other at Yale, but in the years since, we have come to know and draw upon each other's works not infrequently. I must say that when we first began corresponding and chatting about the court and other legal topics, it meant something to me, and I hope to Adam as well, that we were part of the same law school family. Every law school creates its own distinctive society, and when I tell students that they will be interacting with other Illinois law folks, helping them, seeking their counsel, etc., many years from now, I'm speaking from personal experience. Many of you in this room will be meaningful colleagues with each other for decades to come, and the professional values and skills you develop here will knit you together as an enduring community. It's my pleasure to welcome Adam into our community today, and let's hope that this is not the last time he comes and shares his wisdom with us.
Thank you very much, Vic. And the reason I kept calling Vic over the years is because he's really an astute observer of the Supreme Court. You can call up a lot of law professors and they'll pause and give a deep sigh and say, "Oh, I guess it all depends on Justice Kennedy," and think that's a quotation-worthy observation. Vic is actually a much deeper student of the court. It's also a pleasure to give this particular lecture because, as you heard, Paul Van Arsdell had a successful career at Latham & Watkins, and I follow Latham & Watkins these days because it has a quite prominent Supreme Court practice. In fact, it's defending the University of Texas in a major challenge to its affirmative action program that will probably be argued in December. And later on in my talk, I want to talk to you about that. And then later on in my talk, I'd love to get your questions. So as I say things that don't make sense, make a mental note, and we can talk about it later. But what I want to talk to at first is what the court, who's on the court, what the court's been up to, and the diversity case, the affirmative action case I just mentioned, sort of gives you a way into thinking about the Supreme Court. It's an odd moment in the history of the Supreme Court in terms of its membership. In some ways, it's become quite diverse. For the first time in history, it has 3 members who are women, one of whom is Hispanic. It has a black member, only the second in its history. And the justices talk occasionally about diversity in this sense, in this demographic sense. Among the justices who talk about the value of diversity in this sense are justices who are generally hostile to the value of diversity in the academic setting, in the affirmative action setting. Justice Antonin Scalia, for instance, whose scorn for that second kind of academic diversity can be withering, has freely admitted that the presence of Justice Thurgood Marshall, the civil rights era hero, the giant who argued Brown v. Board of Education, that the presence of Justice Marshall at the court's private conferences changed the tenor of the discussion. The 9 of them get together and talk about and vote on cases, just them in the room. And what Scalia said about Marshall was that Marshall could be a persuasive force just by sitting there. He wouldn't have to open his mouth to affect the nature of the conference and how seriously the conference would take matters of race. Think about that. You've probably had a similar experience. The presence of someone from a different background with different experiences can shape the way you think about a problem, not by what he or she says, but just by being in the room. It makes you look at the issue through another person's eyes. The court is simultaneously more and less diverse if we look at another dimension, religion. For the first time in its history, it has no Protestant members. Unthinkable 50 years ago. There are 6 Catholics and 3 Jews, and I think that probably represents progress from a time when there was thought to be a Catholic seat and a Jewish seat, and that's it. We seem to have moved past religion as a marker that signifies something. But in other ways, the court is alarmingly homogeneous. Every single justice attended either Harvard or Yale Law School. 6 went to Harvard, 3 went to Yale, with Justice Ruth Bader Ginsburg getting an asterisk. She started at Harvard, but followed her husband Marty to New York and graduated from Columbia. Now think about that. That gives rise to a court that feels clubby, insular, and elitist. They like to joke, but the jokes are sometimes a little sour. When Chief Justice Roberts, who went to Harvard and Harvard Law School, was asked whether it was a good thing that all of the justices had attended elite law schools, he protested that that was not true. Some of them, he said, had gone to Yale. Justice Elena Kagan, who went to Princeton and Harvard Law School and later served as dean of Harvard Law School, joked that Justice Ginsburg had spent a year at Columbia, slumming it. 3 of the justices are former Supreme Court clerks. Only 1 has ever served as a trial judge. Not one of them has ever run for public office. And I tick off these things, and they may seem normal to you, but in American history, they're quite distinctive, quite odd. All of the justices but 1 are former federal appeals court judges. The exception is Justice Kagan, but even she had been nominated to the D.C. Circuit late in the Clinton administration, never getting a vote in the Senate. Before she joined the court in 2010, it was for the first time in American history made up entirely of former federal appeals court judges. Now, again, that may seem normal. Well, what do you want in a Supreme Court justice? You want a good judge, you might say. But the trend is new. Before Dwight Eisenhower's presidency, about a third of the nominations to the Supreme Court went to sitting judges. Since 1953, more than 2/3 have. Felix Frankfurter, who was a law professor at Harvard before he joined the court in 1939, had a blunt assessment of this phenomenon of former judges. He said, the correlation between prior judicial experience and fitness for the functions of the Supreme Court is 0. Yet the last justice to join the court without a judicial background was William H. Rehnquist in 1972. And he worried about this. He thought that the American legal system was turning into the European one. In Europe, you go to law school, and one of the things you can sign up for to be is a judge. You learn how to be a judge at your age, and then you go into the civil service, and you move your way up the ranks of judges, and you don't have especially high status in society. It's not the capstone to a major public career, a major legal career. It's something you do all your life. And Chief Justice Rehnquist worried that we're turning into that, and that there are problems with that. That's a negative thing. His successor, his former law clerk and successor as Chief Justice, John Roberts, has a different view. He says that since former judges have started to dominate at the court, quote, the methods of analysis and arguments have shifted to the more solid grounds of legal arguments. What are the texts of the statutes involved? What precedents control? The change, he said, has resulted in, and he thinks this is a good thing, a more legal perspective and less of a policy perspective. Now, political scientists will dispute the notion that the outcomes in the cases are different because there are former judges on the court. But it's true that most of the decisions from the current court exhibit a high sheen of legal craft. The justices on the current court are all of them very, very good lawyers. But query, as my law professors used to say, whether June's same-sex marriage case exhibited that high level of legal craft. Now, consider in contrast to the court I've just described, the court that decided Brown v. Board of Education in 1954. Brown, there's little question that Brown ranks high and probably first among the Supreme Court's achievements. It was not composed of a court made up of former judges. It was written by Earl Warren, the former governor of California. Among the judges who joined it, it was unanimous, were a former United States Senator, Hugo Black, and a former Attorney General, Robert Jackson. These days, in contrast to the people who brought to the court experiences from a breadth of public life, we have a much more constrained court, maybe a little out of touch with the experiences of ordinary Americans. It is, in a nice phrase from Walter Dellinger, a former United States Solicitor General, a court of logicians. Now, does diversity in the sense that I've been talking about matter? I'm going to read an extended passage from Justice Scalia's dissent in the same-sex marriage case in June. He seemed to think that it does. Here's what he said. The Supreme Court, he wrote, consists of only 9 men and women, all of them successful lawyers who studied at Harvard or Yale Law School. 4 of the 9 are natives of New York City. Now let me pause for a second because this is important. As a former New Yorker, only 4 of the city's 5 boroughs are represented. Kagan is from Manhattan, Ginsburg is from Brooklyn, Scalia is from Queens, Sotomayor is from the Bronx. So here's the advice, the news you can use advice. If you have Supreme Court aspirations, look at Staten Island. Now, more of Scalia from the marriage dissent. 8 of them grew up in East and West Coast states. Only 1 hails from the vast expanse in between. Who is it? John Roberts from Indiana. Not a single evangelical, I'm still reading Scalia, not a single evangelical Christian, a group that comprises about 1/4 of Americans, or even a Protestant of any denomination. The strikingly unrepresentative character of the body voting on today's social upheaval would be irrelevant if they were functioning as judges. Scalia continues, to allow the policy question of same-sex marriage to be considered and resolved by a select, patrician, highly unrepresentative panel of 9 is to violate a principle even more fundamental than no taxation without representation, no social transformation without representation. So there is Justice Scalia's plea for more diversity on the court. The current court is unusual in one last way that I'll mention. It is for the first time in America closely divided along partisan lines. And here again, this sounds like something that must have always been so, and in fact, it's never been so. What we have today is that every one of the court's 5 more conservative members was appointed by a Republican president, and every one of its 4 more liberal members was appointed by a Democratic president. That may seem normal, but we've never seen a closely divided court that's also closely divided along, call it, these partisan lines. We've become used to partisanship and polarization in every aspect of American life, but it's not normal on the Supreme Court. It wasn't long ago that party affiliation of the appointing president did not predict voting on the court. Think of John Paul Stevens, who was appointed by President Ford, a Republican, and yet was a leader of the court's liberal wing. President Ford, when he was looking for a Supreme Court justice, was said to have asked, "Just find me the best lawyer in America." That's not what presidents ask these days. Justice David Souter was appointed by the first President Bush and yet generally voted with the liberals. Justice Sandra Day O'Connor, the first woman on the court, was appointed by President Reagan, who turned out to be a moderate who trended left in later years. Other Republican appointees who were or became liberals: Warren, Brennan, Blackmun. Byron White may be said to be the only recent example trending the other way. These days, presidents seem to have unlocked the code and to care more, so that the recent appointees have voted exactly as the presidents who appointed them would presumably have hoped. Maybe with an exception we'll talk about. Two appointees of the second President Bush, Chief Justice Roberts and Justice Alito, are reliably conservative. The two Obama appointees, Justices Sotomayor and Kagan, are reliably liberal. Now, you'll learn a lot at law school about how law is kind of a systematic inference from legal materials that can only provide one answer. At the Supreme Court, much more open field, much more open texture. There's a lot more room to maneuver. And I'm not suggesting that politics in a purely partisan sense play a role, but call it ideology, call it judicial philosophy, something like that maps onto what people do, and people seem to come out pretty close to how they would have, how the president who appointed them might have wanted them to vote. Now, the Roberts Court just completed its 10th term, and I would like to draw some general conclusions. And a year ago, it would have been easy, but this last term has been a confounding one. The last term gave rise to a bunch of liberal results, and it's hard to fit into that end-of-term story that I like to write, Roberts moves court to the right. This year I had to write it differently. In general, of course, the court has been pretty conservative, though perhaps only a touch more conservative than the Rehnquist and Berger courts. Think of District of Columbia against Heller, which revolutionized the Second Amendment, Citizens United, which amped up the role of money in politics, and Shelby County, which gutted the Voting Rights Act. Now, the best way to understand this general rightward shift over the last 10 years is to think about the court's personnel. There have been 4 changes that make up the Roberts Court. So sometimes we talk about the Roberts Court as a single entity that lasted 10 years. We tend to talk about courts by the name of the Chief Justice who presided. But of course, each court is a little different every time you have a change. Only one of the 4 changes really mattered, because 3 appointments were 1-for-1 swaps. Chief Justice Roberts for Chief Justice Rehnquist was a conservative for a conservative. Justice Sotomayor for Justice Souter was a liberal for a liberal. Justice Kagan for Justice Stevens was a liberal for a liberal. The defining characteristic of the Roberts Court, which has been in business since 2005, was the 4th swap. In 2006, Justice Alito, a conservative, replaced Justice O'Connor, a moderate, and that move tugged the court to the right. That's the distinctive move in the Roberts Court years. It has changed the course of the court's jurisprudence on abortion, on race, on campaign finance, and on the rights of criminal defendants. So you can look at Supreme Court nominations. All of them are very important. But the ones that really count are the ones where a Democratic president gets to replace a centrist or conservative justice or a Republican president the other way around. So you can pay a lot of attention. We have a fairly old court. 4 of them are 77 years or older. The next president is going to appoint at least 1, maybe 2, maybe 3 justices. And depending on which ones they are, it could transform American life. It will be the subject of vanishingly little discussion in the presidential campaign, and yet it's probably the most important issue over decades in American life. The partisan alignments on the Roberts Court, though, and this is the footnote I hinted at before, may have counterintuitively helped explain its 2012 decision to uphold President Obama's health care law. The court has now turned back 2 major challenges to the Affordable Care Act. The first one in 2012 was a big constitutional challenge that would have gutted the law, but the vote, as you'll recall, was 5-4, with Chief Justice Roberts joining the 4 Democratic appointees to save the law. That alignment, Roberts plus the 4 liberals, had never happened before, and it's only happened one time since. My hypothesis is that Chief Justice Roberts considered what a 5-4 decision going the other way would have looked like. It would have split not only along ideological but partisan lines, but it would have had the 5 Republican appointees in the majority lined up against the 4 Democratic appointees in the minority to strike down a Democratic president's signature legislative achievement in an election year, and that would not have looked pretty. The court likes to insist that it is not a political institution, and such a decision would have been powerful evidence to the contrary. I think the Chief Justice did not like the way that would look. It was certainly not the only factor that went into his calculations, but it may have been one of them. Chief Justice Roberts, even today, is just 60 and will have a long run on the court. I know 60 sounds old to you. By Supreme Court terms, 60 is like a toddler. The Chief Justice can afford to play a long game. And as Chief Justice, he has, and certainly feels he has, a special responsibility to be a steward of the court's reputation and prestige. He's the one who's in charge of the institution's reputation. One thought experiment. Chief Justice Roberts was initially nominated to be Associate Justice Roberts. He was initially meant to take the place of Sandra Day O'Connor, who announced her retirement in 2005, and then Chief Justice Rehnquist died, and the nomination was shifted over. I think an Associate Justice Roberts might have voted differently. I think he would have felt less pressure to be the steward of the court's institutional reputation, and I think his voting would have been more conservative overall. The first healthcare case was badly fractured, the 2012 case, the constitutional challenge, and it elicited a bitter response from the political right. They felt betrayed by John Roberts. In fact, I just saw a series of ads by the Judicial Crisis Network saying no more mistakes. And the mistakes they think Republican presidents have made are Souter, Kennedy, and Roberts. Now, it's true, Roberts has twice voted in a way that helped the Affordable Care Act, but that's about it. John Roberts is a conservative man, and it's the rare moment when he has given the right reason to feel betrayed. But when they feel betrayed, boy, they really feel betrayed. They did not expect to lose at the hands of John Roberts, whom they viewed as a movement conservative from the Reagan era and a reliable ally. And I didn't know how to factor this in. It was really bruising. To this day, the Wall Street Journal can't write John Roberts' name without, comma, the traitor or something like that. And I wasn't sure what kind of reaction this would give rise to when the Affordable Care Act came back to the court this year in a statutory rather than constitutional context. And I think what we saw is that he doubled down, and he was full-throated in affirming the law this time around. Last time around, it was 5-4, but no member of the court joined every part of his reasoning. This year, it was 6-3, and the 6 were united. Nobody wrote separately. And Chief Justice Roberts wrote flatly, Congress passed the Affordable Care Act to improve health insurance markets, not to destroy them. Very different kind of tone. As I was sketching out this talk, I realized that a theme ran through it. Sometimes when you write stuff down, you realize what your theme is. At the Roberts Court, I think one theme is anything worth deciding once is worth deciding twice. And very often it's the second decision that makes the big move. Some examples. In 2007, the court hinted that a major campaign finance ruling was coming. In 2010, it issued Citizens United. In 2009, it criticized a key portion of the Voting Rights Act. In 2013, it destroyed it. In 2013, it ducked the question of whether there is a constitutional right to same-sex marriage, but took a big step in that direction by striking down the Defense of Marriage Act. In June, it established the right to same-sex marriage. Also in 2013, it seemed to tighten the standards for assessing whether and when public universities can take account of race in admissions decisions. This term, you see my theme, the court will take another look at that question of affirmative action. I think it's probably so far the biggest case of the term. The fact that they're coming back to it should make supporters of affirmative action a little bit nervous. The 3 decisions from 2013 that I just mentioned on voting rights, affirmative action, and same-sex marriage were all in one way unsatisfying. Supreme Court decisions, you will learn, or if you haven't already, are meant to do two things. They resolve the particular dispute before the court, which side loses, which side wins, and also announce a legal principle that will apply in hundreds or thousands of cases in the lower courts. In the three big cases in 2013, the court uniformly did one but not the other. One announced the principle but failed to apply it. Two resolved the dispute before it but failed to tell us what the governing principle was. The question for the court in 2013 in the affirmative action case, Fisher against University of Texas, was whether public colleges and universities may grant preferences in their admissions decisions to blacks, Hispanics, and other members of historically disadvantaged races and ethnic groups. Ending such affirmative action reduces the number of African American and Latino students at nearly every selective college and graduate school, and we see Asian Americans and white students gaining admission in the process. Now, there are powerful arguments on both sides of the question. On the one hand, the court has said that the government, and public universities are the government for these purposes, must have a very good reason for classifying people by race. On the other hand, I think most of you would agree that there's a powerful value in educational diversity, that you learn more in a setting in which all sorts of backgrounds and viewpoints are represented, as Justice Scalia told us about what it was like to sit with Justice Marshall at conference. The case in question was brought by Abigail Fisher, a white woman who says the University of Texas rejected her application on account of her race. Now, there are confusing aspects to this. It's not clear she would have gotten in to begin with. It's not clear that she has suffered the kind of direct injury that gives her standing to sue. But on the larger question, the university responded that it must be free to assemble a varied student body as part of its academic and societal mission. The Supreme Court endorsed that view about a dozen years ago by a 5-4 vote in a case called Gritter v. Bollinger. So, and in that case, Justice O'Connor said, we don't want to do this forever, but for the next 25 years or so, I expect this is a good way to do things. We're only a dozen years into it, but there's some reason to think that this Fisher case, which has come back to the court by June, may restructure this question. What Justice O'Connor said was that quotas, numerical quotas in admissions decisions are no good, but that race can be used as one factor among many as part of a holistic review. But Justice O'Connor retired, as I said, in 2006, and many thought her replacement by Justice Alito would open the way for a ruling cutting back on such race-conscious admissions policies, or maybe eliminating them entirely. Instead, curiously in 2013, but this was only the first bite at the apple, in a 7-1 decision with Justice Ginsburg dissenting and Justice Kagan recused, the court said affirmative action plans must be closely scrutinized by courts to see if race-neutral methods could achieve educational diversity. Okay, so there's the principle. So far, so good. But then the court did not apply the principle. Instead, it sent the case back to the Federal Appeals Court in Texas to apply the rule. The appeals court again upheld the Texas plan, and now in June, the court agreed to hear the Fisher case for a second time. It'll probably be argued in December and decided by next June. And you can ask the question of what did we learn from this kicking it back down to the lower courts? I think there was a lot of internal maneuvering on the court the first time to try to find some common ground. Justice Breyer asked about his reaction to the first Fisher decision in one of these public conversations at Aspen, had a one-word response, phew, suggesting that the left had dodged a bullet, and I'm not sure it's going to dodge a bullet the second time. The other two 2013 cases were far more definitive, though, as I say, they lacked what lawyers call a rule of decision, a governing principle. The first concerned the central legacy of the Civil Rights era, the Voting Rights Act of 1965. People bled and died for the Voting Rights Act in an era when lawless Southern officials routinely denied black people the right to vote. The question for the court in 2013, broadly speaking, was whether we still needed the law in an era when the nation has twice elected a black president. Now, that was the second bite of the apple. The first bite of the apple in 2009, the court had already signaled that it had reservations about the part of the law that requires federal review of changes in election procedures in parts of the country with a history of discrimination, mostly in the South. Let me unpack that a little bit. So here's a law that says it's illegal to block people from voting on account of race. And you can sue after the fact in all 50 states. In some states, the history of discrimination was so pervasive that we're not going to have the usual after the fact lawsuit. We're going to say the law that the state enacts is not actually a law until they come to Washington and get federal approval for their state law. Now, that's a radical notion in terms of federalism. The Supreme Court 3 times said it was justified and required given our terrible history. And the question for the Supreme Court was whether we still needed that regime. That's Section 5 of the law. And whether we're still entitled to say some states, but not others, are subject to this kind of upside-down federalism. It's a system that tells states that when they enact a law changing voting procedures, moving a polling place, redrawing election district, requiring voter ID, cutting back on early voting, the law does not count until federal officials bless it. There's no other area of the law that works like this, and no one disputed that Section 5 imposed serious federalism costs. So in 2009, in another one of these lopsided decisions that didn't do very much, the court, by an 8-1 vote, suggested that the law's days were numbered. We are now in a very different nation, Chief Justice Roberts wrote. Whether the conditions continue to justify such legislation is a difficult constitutional question we do not answer today, he said in 2009. He invited Congress to have another look at the part of the law that singled out some states but not others. And Congress, of course, did nothing. The case returned to the Supreme Court on this question of whether the singling out of states, the so-called coverage formula, could still be sustained, particularly given as it relied on very old data. In the end, in a decision that it was in a way modest, in 2013, the court struck down the coverage formula. Until Congress enacts a new one, which is to say never, that means Section 5, the heart of the Voting Rights Act, is gone, freeing 9 states, mostly in the South, to change their election laws without advance federal approval. And as you know, they wasted no time, particularly in the area of voter ID. Some commentators have said that the voting rights decisions are an example of the long game Chief Justice Roberts seems to be playing in several areas of the law, including campaign finance and affirmative action. That he puts down a marker today, he plants a seed today, 5 years later he returns to it. Sometimes he's gotten colleagues on the left, in order to get the short-term victory, to sign on to a legal principle that may come back to bite them. And Justice Ginsburg, in public interviews, including with me, has suggested there may be some truth to that she regrets signing on to the 2009 version of the Voting Rights Act case because the chief then used the language in it against her side later on. And that may be the reason that she was the only justice who didn't sign on to the 2013 version of the Fisher case, because there's language in the 2013 version of the Fisher case that we're likely to hear more about in the 2016 version of the Fisher case. So a 60-year-old justice like Chief Justice Roberts can afford to play a long game. Justice nearing the end of his tenure, say Justice Scalia or Justice Kennedy, may have a different idea of how to secure a legacy, might want to go big faster. Justice Ginsburg told me she certainly thought that the voting rights case was very aggressive, and that the court in particular has gotten very activist. She said to me in 2013, if it's measured in terms of readiness to overturn legislation, this is one of the most activist courts in history. The voting rights decision, she said, was stunning in terms of activism. Now, if you ask political scientists, they'll tell you that this court is no more activist than any of the immediately predecessor courts. It doesn't overturn a lot of statutes, maybe 2 a year. It doesn't overturn a lot of precedents, maybe 2 a year. When it does, though, it tends to move the law to the right. Justice Ginsburg also told me that she thought, as a general matter, the court would be wise to move incrementally and methodically. It had moved too fast, she said, and she's a great feminist, but nonetheless, she said, she's definitively the greatest women's rights litigator in American history. But nonetheless, she said Roe v. Wade, the 1973 decision that established the constitutional right to abortion, had moved too far too fast. The court should have struck down, she said, the extremely restrictive Texas law in the case and not done more, moving in an incremental fashion. She said, I think it's inescapable that the court gave anti-abortion forces a single target to aim at. Unelected judges decided this question for the country, and never mind that the issue was in flux in state legislatures. Now, there are some who dispute her history, some who say that without Roe, there would not have been progress on the right to abortion. But nonetheless, it does suggest a cast of mind about how fast the court should move. And I raise this because it gives you a sense of what the court did in the same-sex marriage arena. And if you are a supporter of same-sex marriage, you have to say the court was brilliant. It seemed to mirror the pace of progress in opinion polls and in state legislatures and at voting booths, and it didn't get out very far in front of the country, and it did that through some very interesting tactical moves. In 2013, the court, the first bite, had the question of whether there's a constitutional right to same-sex marriage, and it ducked the issue and allowed the case to percolate further. And as recently as just this last October, a year ago, the court turned down a bunch of appeals court decisions, federal appeals court decisions, that had struck down state same-sex marriage bans. I would ordinarily think that if a federal judge strikes down part of a state constitution on federal grounds, the Supreme Court has an obligation to step in. Justice Ginsburg ran around and said, well, there's no split in the circuits. That's true, and a split among federal appeals courts is typically a reason the Supreme Court takes a case, but the notion that federal judges are striking down state constitutions would have seemed to me a very good reason for the court to get involved in October. What it did instead was allowed these decisions to go into force, allowed same-sex marriage to spread to 36 or 37 states, and let the nation get used to it. And that number is very, very historically meaningful. Every time you get to a point where a relatively small minority of states is still engaged in the practice, the court feels much more comfortable. And I think the American public feels more comfortable seeing the court feel more comfortable in making a move. So there were about 15 states that still had laws requiring segregated schools in 1954 when the Brown case was decided. About 15 states still banned interracial marriage in 1967 when the court struck them down in Loving against Virginia. About 15 states still made gay sex a crime in 2003 when the court struck down those laws in Lawrence against Texas. And that's the number we had when the same-sex marriage case arrived back at the court this last term. Let me take you back to the end of the 2013 term, though. The court then did two things. It ducked the major question, but it ruled that married same-sex couples, but it struck down the Defense of Marriage Act. The Defense of Marriage Act was a federal law that said federal benefits cannot be paid to same-sex couples married in states that allow such unions. So it wasn't telling anybody, it wasn't forcing anybody to get married. But if you were already married in Massachusetts, if you were an opposite-sex couple, you'd get federal benefits. If you were a same-sex couple, you wouldn't. As a simple matter of fairness, that didn't seem right. And the court struck down that law. That's all it did in 2013. And in 2013, that closely mirrored public opinion at the time, which favored treating married same-sex couples fairly, but also favored leaving the decision of whether to allow same-sex marriage to the states. So the case on the Defense of Marriage Act, United States against Windsor, was far more important from a legal perspective because the constitutional basis for striking down the law helped these lower courts I was just talking about figure out how to strike down bans on same-sex marriage. But characteristic of an Anthony M. Kennedy opinion, it was a little hard to tell what the basis of the decision was. It was a stew of federalism, equal protection, and due process, and another example of a decision that announced an outcome but did not give the crispest account of its legal reasoning. There were reasons in the Windsor decision to think Kennedy meant for the matter to be left to the states. That would suggest upholding the state bans. And there was very strong language about the dignity of gay couples and gay families that suggested a different outcome. Now, you could say the same thing about his opinion in Obergefell, the same-sex marriage case, which is rhetorically soaring, if legally a bit muddled. But it has done its job, giving rise, in the greater scheme of things, to vanishingly little backlash or resistance. I mean, we hear about a clerk in Kentucky, and the fact that we're hearing about a clerk in Kentucky suggests that this transformative decision, really a landmark civil rights decision, is being digested and accepted by the American public with great ease, in contrast to, say, Brown, which gave rise to massive resistance. And that also suggests that the court has played its cards right, if your goal is to establish such a right. So let me conclude before we turn to questions with just a few thoughts about what we've learned about the Roberts Court after 10 terms. If I were talking to you a year or two ago, I would have referred you to 4 sets of political science data that showed the court to be, by a modest amount, the most conservative in legal memory. Even then, I would have noted that the court's decisions have hardly been uniformly conservative. The justices have, for instance, limited the use of the death penalty. Now, it's still true that 3 of the 5 most conservative justices of the 35 who have sat on the court since 1946 are serving now. So 3 of the top 5, and they are Justices Alito, Scalia, and most conservative of all, Justice Clarence Thomas. The other 2 of the top 5 were Chief Justices Berger and Rehnquist. Chief Justice Roberts and Justice Kennedy are in the top 10. So by that measure, it's quite conservative court. Justice John Paul Stevens, who retired in 2010, had his own way of telling the court's direction. In an interview when he retired with me, he told me that every one of the 11 justices who had joined the court since 1975, including himself, were more conservative than his or her predecessor. I think that can't be right about Justice Ginsburg, and it may not be right about Justice Sotomayor, but it's generally right. The court is also more friendly to business interests than any court since World War II, and the 2 justices most likely to vote for business interests of the scores who have served in those years are the 2 George W. Bush appointees, Justice Alito and Chief Justice Roberts. Now, some of these same measures, when we look at the term that just ended, suggest that this last term was notably liberal, and the health care and marriage cases certainly support the view, along with a host of other decisions in housing, voting, and employment cases. One statistic I never thought I'd see today that we have this term is that Justice Stephen Breyer, a liberal of all people, was in the majority more than any other member of the court, 92% of the time, handily beating the usual winner, Justice Kennedy, by 4 percentage points. Now, there are responses to those numbers, and Vic and I were talking about this before I came up here, about how to think about whether this is an authentically liberal term, because, of course, they're not deciding the same cases every year. The only way you'd know is whether they're more liberal than last term if the same 9 people decided the same case every year, and that's a little hard to get that experiment up on its feet. So the case mix may have an impact. Litigation tactics may have an impact. Strategic voting about what cases to put on the agenda. As you know, it takes 4 justices to put a case on the agenda, but 5 to win. So there's strategic behavior about which case you're going to try to get on the merits docket, because you want that case on the merits docket that your side is likely to win. But anyway, the current term has really caused this reporter's head to scratch a little bit. The next term, the numbers may be very different. In addition to the affirmative action case we've talked about, the court will hear major cases on voting, class actions, public unions. The early betting is that the right side of the court has reasons to be hopeful this year. We'll see. Stay tuned. And now let's turn to your questions. I'm told there are microphones, so please raise your hand and we'll get one to you. Wait for the microphone.
So we have this recent, more liberal turn. It could just be an outlier. It could be a number of things. But I'm wondering, since you have so much information about the court, whether you think that there are changes going on behind the scenes in the kind of practices and the ways that justice interrelate. In particular, the way they're interacting on cert petitions, what you call strategic voting to get them in, the things going on at the conferences, the way drafts kind of go back and forth. Is there more interaction in the hallways? Really sort of any of these kinds of things. I know you talked about Roberts with thinking about the long term, but my sense is that there was a time when the court was very kind of atomistic, and maybe there's some more interactive things happening. Is there any basis in that?
In terms of interaction, collaboration, they are surprisingly isolated. They're really 9 little law firms, the 9 chambers, and they interact almost entirely in very formalized ways at brief conferences and then on paper. I think what happened this last term is that we have a court that is fundamentally conservative, that liberal interest groups try to keep cases out of. Conservative interest groups try to get cases too, but it's possible to go to the court with a case that's too ambitious even for the current court. And it's possible that you take such a case to the court and the 4 most conservative justices say, hey, let's give it a shot. Maybe we win, maybe we don't. We're not going to be any worse off if we put this on the merits docket and lose, because they're trying to move the law to the right, and the worst case scenario for us is the status quo. Now, Vic has written interestingly about how you may think that, but nonetheless, aspects of the resulting decision can still come back to bite you. But I think that's fundamentally what's going on. Yes.
Well, some years ago
Was it worth the wait?
Yeah, there was talk about, and a book came out about the Supreme Court that talked about the justices occasionally trading votes. I wondered if there's if you have any feeling about that, any thought about whether that happens, even in the loosest political sense, with this court.
I really don't. I believe them. I take them at their word. They say so adamantly that tomorrow is another day, that you vote with me on this case doesn't mean I'm going to vote with you tomorrow on that case. One question I didn't talk about, but which has gotten a lot of attention, it's a little bit like your question, but the opposite. What if Justice Scalia writes something so mean about me that I'm disinclined to help him out next time around? And what he wrote about Justice Kennedy in the marriage case was really cutting and not without some substance. And it makes me wonder what it's like to be, and Justice Kennedy has a good self-regard, what it's like to sit there while, when the decision is announced, Justice Scalia says he would rather hide his head in a paper bag, even if he agreed with the result, than to join the kind of legal reasoning Justice Kennedy put forward. I don't know what impact that has on Justice Kennedy. It's widely thought that Justice Scalia managed to alienate a likely ally, Justice O'Connor, by going after her, although we now see in milder terms than he had available to him. All the way back there. I would love someone even younger to ask me a question. Here comes.
While we're waiting for that, I have a very quick question.
Yes.
So, just thinking more about the long game, when I think about the opinions that you're describing that Roberts has, maybe orchestrated, I don't know. I mean, I'm thinking long game in terms of political long game. So, Citizens United, the Voting Rights Act, even the affirmative action cases that, kind of shape the future, politicians and leaders of this country. I mean, is that a potential long game that he's playing too? I mean, I realize this is wildly speculative, but you talked about it in terms of deciding, an opinion today that has nuggets of language that could be used in an opinion that, comes along in 2 or 3 years. But the long game that I'm thinking of is one that could actually play decades in the future, which is, shaping the political landscape. Is that part of the strategy?
I think it's a similar phenomenon. It's different from the long game I'm talking about. In a sense, all law is the long game in that sense, that you're shaping society in a way. And I guess the question, though, to come in a little more finely on your point, is he shaping the political system in a kind of gerrymandered sense that it's hard to dig your sense out of, even if some years from now we have a court that might be inclined to go in a different direction? or whether, in fact, the president who's likely to appoint the next justice may be more likely to be of one party because of how the political system has been engineered. That's an interesting point. I'm not going to speculate about whether he has that in mind, but that may be the consequence intended or not of some of these decisions.
Okay, my question is like just before the Roberts Court, because you've talking about Justice Ginsburg. In Booker, there was a 5 majority finding the federal sentencing guidelines unconstitutional, and then there was a 5-person majority that said the remedy was, instead of saying go back to Congress and start all over, they're advisory. And Ginsburg is the key vote.
And yet didn't write a word, right?
Didn't write a word. And I wondered, since you talked to her, did she ever say anything about why she didn't write a word? Nobody in my world has a clue about what she was thinking.
We've not discussed the subject. She did say at a Duke Law event not long ago, when asked whether she was tempted to write separately in the marriage case. So the marriage case was Justice Kennedy writing for the 5 more liberal justices, and 4 different dissents, none of them commanding 4 votes. So you have a wholly unified left side of the court, which is a phenomenon this year, and a quite fractured right side of the court. And Neil Siegel, her former clerk, asks her, were you tempted to write separately? And she looks at him like he's an idiot and goes, what do you think? She did have things she wanted to say, and she went on to say, I certainly would have written more about equal protection. But then she said, but I think it's very important for us to speak with one voice. And that decision, fractured enough and hard to follow enough as is, probably would not have benefited from additional writing from Justice Ginsburg. Great. Bless you.
So thank you for coming and speaking with us today. As a result of a lot of these decisions, you've talked about kind of the backlash against Justice Roberts. There have been some presidential candidates who have endorsed, amending the Constitution to change the way the Supreme Court operates or the way nominees are appointed. Do you think that backlash or that public opinion is kind of widely shared either on the right or the left, and whether you think that has any possibility of kind of gaining any traction as a result of these decisions?
So the second question first. No, none of this talk about term limits or anything that would require an amendment to the Constitution to reshape how the Supreme Court does its work or how people get on the Supreme Court is a practical non-starter. The first question is this salient to the public? No. The court really does not follow the work of the court. The public could maybe name 2 cases and 2 justices, and tends to be quite out of touch even with where the court is. So are there elements of the Republican base who might be energized by Ted Cruz going after the Chief Justice? I imagine so, but it doesn't have widespread political salience. And I continue to think, there are a small handful of examples where Roberts didn't do what his usual allies might have wanted him to do, but I think it's idiotic on the right. John Roberts is, you could do a lot worse than John Roberts if your goal is to be conservative.
A quick follow-up. Do you think that then shapes any of the Supreme Court's decision-making behavior in terms of their being afraid to take a certain stance due to that backlash?
I guess I think not. I guess, in fact, the Affordable Care Act cases suggest a kind of doubling down. The great backlash about Citizens United, which we haven't talked about at all, I think is only emboldened the 5 who believe that's correct as a matter of the First Amendment. So no, I don't think this is a court that is going to be bullied by editorial pages or public opinion or whatever. Not always the case. The reaction to the court's death penalty case in the late 60s did seem to cause the court to rethink where it was going on the death penalty.
You talked a lot about the ideological polarization of the court, though the conservative justices and the liberal justices, and now Roberts and many's concern over that. Do you see that as just a phase, or do you worry that it becomes the new norm, that a Democratic nominee always votes liberal and vice versa?
I'm not going to say I'm worried, but I'm going to, just as a descriptive matter, say that we seem to live in an era where the parties care an awful lot about these ideological questions, and they're likely to want to get people who are reliable. There's also a trend toward getting people who have worked in Washington who are really well known. So if you think about some of the exceptions, Stevens from Chicago, Souter from New Hampshire, they weren't well known in Washington. John Roberts served in the White House. Alito and Kagan served in the White House. Alito served in the Justice Department. People had lunch with them. They knew what these people's politics really are. So that's another way to be less surprised. One thing we have on the current court, which is not always the case, is really one justice, a single justice in the ideological middle. It wasn't so long ago when we had O'Connor and Kennedy in the middle, and going back a little bit more, you had 2 or 3 votes who might be in play. Now on the current court, when someone argues to the court, it sometimes feels like they're arguing to one guy. And when Justice Kennedy makes a point, everyone perks up and tries to find a way to say, "That's what an astute point, Justice Kennedy." And all I would modify it with is, the opposite.
You mentioned that this court has been kind of making a habit of visiting certain cases and then visiting similar cases or going back to them again. And you mentioned affirmative action. Is there anything else kind of on the horizon that we can expect maybe this court to address in the next few years that they've maybe hinted at?
Well, one thing they've hinted at, it couldn't be more direct. There's a case on the docket about public sector unions, and the court has twice already said they have a problem with making non-members of public sector unions pay so-called agency fees, the equivalents of dues. The legal issue is a tiny bit complicated, but the larger takeaway is public sector unions could really, really take a hit this term. And as recently as a couple of years ago, 5 justices suggested they were almost ready to go. So that's another instance of the court coming back to an issue. Now, it may be that I overstate my case, because as I've covered the court for 7 years, and you do see them chewing over aspects of the same issues over and over again. But certainly in these major cases, there tends to be a kind of runway case and a takeoff case, and I think this new public sector unions case, Friedrichs, is another example. Right behind you.
Yeah, this is more from like the journalism, like covering the Supreme Court perspective. I was just wondering, how much access do you really get to the Supreme Court, and how often do you speak to the justices, like on the record, or like do you just follow dissents, or?
So I'll answer the last question directly. I've had on the record interviews with Sotomayor, Breyer, Ginsburg, and Stevens. So some. They tend to have a book coming out, and occasional other interactions, not a ton, and not much of it of any journalistic use at all. In fact, kind of journalistically counterproductive. If you have a nice interaction with someone, and then you feel you want to write something mean about them, you might pull your punches. But this overstates the question in a way. It's a question I get all the time. It's a perfectly good question, but in a sense, it's the wrong question, because my job is not really journalism in the standard sense. It's not like covering the Pentagon and trying to find out secret stuff. My job is to, on deadline, translate complicated legal materials into, I hope, accessible journalism, and that uses a teeny-weeny part of the journalistic toolbox. I'm not really calling people up for quotes. I'm working off the public materials of the court, and the court in one sense quite secretive, but in another sense not. It explains its work, it holds public arguments, it issues reasoned decisions, and the journalistic challenge, which is only amped up in the internet age, is to take that 180-page decision and make 900 words of sensible journalism out of it, like immediately. And that's a challenge, but it's not the kind of challenge that would help me if I could, get the Chief Justice on the phone.
Well, I think we're nearing the end of the hour. Adam, we actually have a little gift so you can remember your time here. Thank you so much. Listening to Adam makes me kind of sad that I didn't spend more time with him in law school, because rarely are you going to get as clear and brilliant and yet entertaining and witty set of remarks about the court. So we really thank you for coming, and you're very kind to do so.